I have learned that people rarely steal land with bulldozers. Most of the time, they steal it with paperwork that nobody bothers to question. The first thing I noticed when I returned to the fishing property my grandfather left me was not the water. It was the 13 luxury lakefront retreats standing exactly where our family had always launched our boats. For a moment I honestly thought I had driven onto the wrong road. The quiet shoreline I remembered had been transformed into a busy vacation destination filled with parked trucks, golf carts, picnic tables, rental signs, and families carrying fishing poles toward the docks. Children laughed as they ran between the cabins, couples relaxed on covered porches overlooking the lake, and employees wearing matching shirts welcomed arriving guests into a small office marked with the Homeowners Association logo. Nothing about the place suggested uncertainty. Everything looked permanent, organized, and profitable. I pulled my truck onto the gravel shoulder and sat there for several minutes, trying to understand how an entire resort could appear on property that had belonged to my family for generations. Before stepping out, I unlocked the small fireproof document case I always carried behind the driver's seat. Inside were the certified deed, the title policy, and the probate documents confirming that every acre of the fishing property had passed to me after my grandfather's death. I carefully compared the legal description to the landmarks surrounding me. The shoreline matched. The access road matched. The old oak trees matched. Even the narrow fishing cove where my grandfather taught me to cast a line appeared exactly where the survey described it. The only thing missing was the empty shoreline that should have been there. Instead, 13 finished retreats overlooked the water as if they had always belonged there. I quietly walked toward the main office without saying a word to anyone. Guests checked in, employees handed out keys, and several trucks unloaded fresh supplies for the weekend. A large sign near the entrance announced that every cabin had already been reserved months in advance. Another banner advertised that the entire lakeside retreat would soon become part of an expanded luxury development, after a sale scheduled only 5 days later. That single sentence immediately caught my attention. Someone intended to sell property that I believed was still mine. Before speaking to anyone, I used my phone to photograph the cabins, the registration office, the parking areas, the docks, the utility connections, and every visible sign showing the Homeowners Association name. I also recorded the entrance road leading directly through my property because every guest had entered using the same private access route identified in my deed. Only after documenting everything did I walk inside the office. A woman wearing a professional blazer greeted me with the confidence of someone completely comfortable in her authority. She introduced herself as Melissa Grant, President of the Homeowners Association, and politely asked whether I was checking in for the weekend. I smiled and introduced myself as the owner of the fishing property. Her expression barely changed. She calmly explained that the lakeside retreat had served the community for years and assured me there must be some misunderstanding. When I asked who had given the Homeowners Association permission to build 13 luxury retreats on my land, she answered without the slightest hesitation. She told me the community had always owned the shoreline and that every record would prove it. I thanked her for the conversation, wished the guests an enjoyable afternoon, and walked back to my truck without raising my voice. If Melissa truly believed every record supported her claim, then either I had inherited the biggest mistake of my life, or someone had built an entire business on paperwork they had never actually read. As I started the engine, my eyes stopped on a faded mortgage reference stamped across an old parcel identification sheet inside my document case, and for the first time I wondered whether ownership was not the only secret still hiding beneath that shoreline. I have never believed that the truth hides forever. It usually waits in a filing cabinet until someone has a reason to open the right drawer. Instead of returning to the lake, I drove directly to the county records office with the faded parcel sheet resting on the passenger seat beside the certified deed my grandfather had carefully preserved for decades. The mortgage reference printed across the old document bothered me because I could not remember seeing a recorded release among the papers I inherited. If the mortgage had actually been satisfied years ago, there should have been a clear discharge recorded with the county. If it had never been released, then something much larger than an ownership dispute might be hiding beneath those 13 cabins. The records office was unusually quiet that afternoon, giving me enough time to request every document connected to the property since the original development was approved more than 20 years earlier. A county records specialist named Olivia Bennett greeted me professionally and asked for the parcel number. As soon as she entered it into the system, she frowned slightly before opening another database normally used only for historical filings. She explained that the ownership history appeared unusually complicated because multiple development applications had referenced the shoreline over the years, even though the recorded parcel itself had changed very little. She printed the chain of title first. Every transfer matched the documents inside my case. The property moved from my grandfather to his estate, and then legally to me. Nothing suggested the land had ever been conveyed to the Homeowners Association or to any developer. That confirmed my ownership, but it did not explain how 13 luxury retreats had been built without anyone questioning the title. I then asked Olivia to locate every mortgage ever recorded against the parcel. She quietly disappeared into the archive room before returning with several certified copies. We spread them across a large table, arranging them by date. The original mortgage had been issued more than 2 decades earlier to finance improvements planned during the first phase of development surrounding the lake. I expected the next document to be a satisfaction of mortgage. Instead, there was nothing. No recorded release. No discharge. No substitution. No termination. Olivia searched again using alternate indexing methods in case the release had been filed under another reference number. Nearly 20 minutes later she looked at me and slowly shook her head. According to every official record available, the mortgage remained open. I asked whether that was even possible after so many years. She answered carefully, explaining that mistakes occasionally happened, but an unreleased mortgage could continue affecting title until properly resolved. Before leaving, I contacted Benjamin Foster, an attorney specializing in property law, and met him at his office with copies of everything Olivia had provided. He reviewed the chain of title, the mortgage, and the development filings without interrupting. Finally, he leaned back and asked a question that completely changed how I viewed the entire situation. "Have you confirmed whether the Homeowners Association ever examined the chain of title before building those cabins?" I admitted I had no idea. Benjamin immediately ordered a professional title examination and requested every recorded document affecting the parcel. As I prepared to leave, he stopped me with one final observation. If that mortgage had truly never been released, ownership might not be the only thing still attached to the land. Someone could still possess the legal right to enforce the debt itself. When the preliminary title report arrived less than an hour later, the name listed as the current holder of that right made me read the page twice before I believed what I was seeing. The legal successor entitled to enforce the unreleased mortgage was not a bank, a developer, or the Homeowners Association. It was me. I have always believed that paperwork tells the truth long before people are willing to admit it. Less than an hour after Benjamin Foster showed me the preliminary title report, we were already sitting across from Andrew Collins, one of the most respected title examiners in the county. Benjamin wanted an independent review before taking another step because what we had uncovered sounded almost impossible. Andrew carefully compared the certified deed, the probate records, the original mortgage, and every recorded assignment connected to the property. He ignored assumptions and focused only on legally recorded facts. Nearly 40 minutes later, he placed a fresh title diagram in front of us. Every one of the 13 lakefront retreats had been constructed on the exact same legal parcel inherited from my grandfather. None of the cabins had ever received an individual legal description. None had been divided into separate lots. None possessed an independent chain of title. Instead, every structure relied entirely upon the single parcel that remained subject to the unreleased mortgage. That meant the entire resort stood on one uninterrupted piece of property. The realization changed the case completely. This was no longer simply a disagreement over ownership. Every cabin shared the same legal weakness. Andrew then showed us another document I had never seen before. Several years earlier, the developer had filed paperwork describing future phases of the lakeside project, but those plans referred only to proposed improvements rather than completed legal subdivisions. The county planning department had approved building layouts, parking areas, and utility locations, yet no recorded subdivision plat had ever created separate ownership interests for the cabins themselves. Benjamin quietly smiled for the first time that afternoon because he immediately recognized what that meant. If the parcel remained intact, every improvement standing on it remained legally connected to the same property. Before I could fully process that information, Andrew opened another folder containing recent title activity. A purchase agreement had been recorded only weeks earlier, indicating that an outside investment company intended to acquire the entire lakeside retreat business. The scheduled closing date was only 3 days away. Suddenly the countdown became very real. If the sale closed before we completed our legal review, a new owner could become involved in an already complicated title dispute. Benjamin immediately contacted the closing attorney handling the transaction and requested confirmation of the scheduled transfer. The response came back within the hour. The buyer had already deposited substantial earnest money and expected to complete the purchase exactly as planned. What surprised us most was that the preliminary title commitment prepared for the buyer made no mention whatsoever of the unreleased mortgage or the unresolved ownership questions we had just discovered. Either the issue had been overlooked, or someone believed it no longer mattered. Benjamin refused to speculate. Instead, he instructed Andrew to prepare a certified report documenting every title defect and every recorded inconsistency affecting the property. While those documents were being assembled, I drove back to the lakeside retreat before sunset. Families continued checking into the cabins, employees unloaded supplies for another busy weekend, and Melissa Grant stood outside greeting arriving guests with complete confidence. Watching everyone enjoy the property reminded me that most of them had no idea they were standing in the middle of an unfolding legal disaster. I had no interest in disrupting their vacation or creating unnecessary conflict. My responsibility was to uncover the truth before innocent people became caught in something they never caused. As I prepared to leave, I noticed survey crews placing small construction stakes near the shoreline where a new marina expansion was apparently about to begin. One of the workers casually mentioned that excavation would start the very next morning because the future owner wanted the entire expansion finished before the property officially changed hands. The fastest way to uncover a hidden mistake is to compare what people believe with what the official records actually say. The morning after I watched survey crews preparing to expand the marina, Benjamin Foster and I drove straight to the county planning department instead of the construction site. If heavy equipment started working before we understood exactly how those 13 retreats had been approved, the legal situation could become even more complicated. Benjamin requested every planning map, subdivision exhibit, and engineering drawing connected to the lakeside development. A planning supervisor brought several oversized map books into the conference room while Olivia Bennett joined us with additional certified property records. We placed the recorded deed beside the official planning maps and immediately noticed something neither of us had expected. The planning maps labeled the shoreline surrounding the retreats as a common recreation area managed by the Homeowners Association, yet the recorded deed still described the exact same land as one privately owned parcel with no recorded transfer. 2 official county records were describing the same property in completely different ways. Benjamin asked whether the planning maps carried legal authority to transfer ownership. The supervisor answered without hesitation. They did not. Planning maps existed only to illustrate proposed development. Ownership could change only through properly recorded legal documents. That answer explained part of the mystery but opened another one. If the planning maps had never changed ownership, why had everyone acted as though they did? Olivia searched the historical archive while we reviewed older engineering files stored in the department basement. After nearly an hour, she returned carrying a faded binder containing correspondence between the original developer and the county engineering office. One memorandum referred to an attachment identified as Development Exhibit 7, which supposedly documented the future transfer of shoreline rights after construction had been completed. Benjamin immediately asked to see the exhibit itself. The planning supervisor searched both the paper archive and the digital records system before quietly admitting it could not be located. Every index confirmed the attachment had once existed, but the document itself had disappeared from the county file. That missing exhibit instantly became the most important unanswered question in the entire investigation. If it had transferred ownership, Melissa Grant might honestly believe the Homeowners Association controlled the property. If it never became effective, every assumption made over the past 2 decades rested on incomplete records. Benjamin requested a certified search through the state archive while I decided to speak with Melissa once more before rumors spread through the community. She met me outside the rental office where guests continued arriving for weekend reservations. I calmly explained that county records contained conflicting information and that a critical historical exhibit was missing from the official file. Instead of becoming defensive, Melissa admitted she had never personally reviewed the original development documents. Every Homeowners Association board before hers had relied on planning maps and inherited binders describing the shoreline as community property. She genuinely believed those records were accurate because no one had ever challenged them. Her honesty changed my understanding of the situation. I no longer believed she had created the problem. She had inherited it just as I had inherited the land. Before our conversation ended, her telephone rang. After listening for only a few seconds, the color slowly disappeared from her face. The investment company purchasing the lakeside retreat had just demanded immediate proof that the Homeowners Association possessed clear legal ownership of every cabin before the scheduled closing only 2 days away, and for the first time, Melissa had no document she could confidently provide. The biggest secrets are usually hidden inside documents that everyone assumes have already been verified. Melissa Grant's phone call stayed in my mind long after I left the lakeside retreat because for the first time she sounded less like an opponent and more like someone realizing she had inherited a problem she never created. While the investment company demanded proof of ownership before the closing scheduled only 2 days away, Benjamin Foster received a message from the state archive confirming they had located additional historical records connected to the original development. We drove there immediately because every unanswered question seemed to point back to the earliest days of the project. The archive supervisor placed several preserved engineering files, legal correspondence, and meeting minutes on a large examination table. One folder immediately stood out because it contained internal memoranda exchanged between the original developer, the engineering firm, and legal counsel before construction ever began. Benjamin carefully reviewed each page while I organized the documents by date. The timeline became clearer with every file we opened. Nearly 23 years earlier, the developer had planned to purchase the shoreline from my grandfather before constructing any permanent vacation facilities. Preliminary designs for the cabins had already been completed, but every legal memorandum repeated the same condition. Construction could not begin until ownership, or a permanent easement, had been secured. Then we found the document that changed everything. It was an internal electronic mail conversation printed for the project file. One executive asked whether construction should be delayed until negotiations with my grandfather were finished. Another executive answered that postponing the project would cost too much money and suggested moving forward because they believed the ownership issue could be resolved later. The final message ended with a sentence that filled the room with silence. It stated that the probability of anyone challenging the shoreline ownership after construction was extremely low. Benjamin slowly placed the document beside the certified deed without saying a word. For the first time, we possessed evidence showing the original developer knew ownership remained unresolved before the first cabin was ever built. That discovery completely changed my understanding of the situation. Melissa and the current Homeowners Association board had inherited mistaken records, but the earliest decision-makers appeared to understand the legal risk from the beginning. Before leaving the archive, Benjamin requested certified copies of every memorandum because they would become critical evidence if the dispute reached a formal hearing. As we walked outside, Olivia Bennett called with another update from the county records office. The investment company's attorneys had officially suspended the scheduled closing until ownership questions were resolved, preventing the property from changing hands only 48 hours before the planned sale. The countdown had shifted from a private investigation to a public legal issue. Later that afternoon, Melissa asked to meet us at the retreat office. She quietly admitted that after reviewing decades of Homeowners Association records, she could not find a single recorded deed, easement, or transfer granting the shoreline to the association. Every board had relied on planning maps, newsletters, and community handbooks instead of recorded property documents. She looked at Benjamin and asked what would happen next if the mortgage and title defects were confirmed. Benjamin answered honestly. Because I now held the legal right associated with the unreleased mortgage, foreclosure might become a lawful remedy affecting every structure standing on the parcel. Melissa lowered her eyes toward the lake, understanding the consequences for the first time. Before anyone could say another word, Benjamin received formal notice from the county that an emergency public hearing had been scheduled for the following morning, and every historical document we had uncovered would become part of the official record before any further legal action could proceed. I have learned that the law rarely rewards the person who speaks first. It rewards the person who arrives with the complete record. The emergency hearing began early the next morning inside the county administration building, long before the investment company's scheduled closing could move forward. The hearing room quickly filled with county officials, attorneys, surveyors, representatives from the investment company, members of the Homeowners Association Board, and residents who had spent years believing the lakeside retreat belonged to their community. Melissa Grant sat quietly beside her attorney with several binders spread across the table, but her confidence from our first meeting had been replaced by careful uncertainty. Benjamin Foster reminded me that our responsibility was not to accuse anyone. It was simply to present the historical record exactly as it existed. The county hearing officer opened the proceedings by explaining that conflicting property records required immediate review before any additional transfers, construction, or financing could continue. Benjamin presented the certified chain of title first. Every recorded transfer demonstrated uninterrupted ownership of the shoreline through my family until I inherited the property. Olivia Bennett then introduced the mortgage records showing that the original development loan had never been formally released from the parcel. Andrew Collins followed with his title examination, explaining that all 13 lakefront retreats remained attached to one undivided legal parcel because no separate subdivision or individual ownership documents had ever been recorded. Each new document reinforced the same conclusion from a different direction. The hearing officer then requested the historical engineering correspondence recovered from the State Archive. Benjamin carefully submitted the certified memoranda revealing that the original developer knew negotiations with my grandfather had never been completed before construction began. The printed electronic mail conversation confirming the decision to continue despite unresolved ownership immediately captured the attention of every official in the room. No one interrupted while the hearing officer slowly read the final sentence aloud. After several moments of silence, the county attorney explained that planning maps could never transfer ownership, and an unreleased mortgage combined with an uninterrupted chain of title created significant legal issues requiring immediate correction. Melissa then stood and addressed the hearing herself. She admitted that every Homeowners Association board had relied upon planning maps, community manuals, and inherited administrative records rather than recorded property documents. She apologized for asserting ownership she genuinely believed existed and acknowledged that neither she nor the current board had ever discovered the historical legal defects. Her statement changed the atmosphere completely. The discussion was no longer about personal blame. It became an effort to correct decades of administrative misunderstanding before more innocent people became involved. The investment company's attorney then announced that his client had formally withdrawn from the purchase until the legal status of the property could be conclusively resolved. That decision immediately stopped the scheduled sale only one day before closing. The hearing officer concluded that sufficient evidence existed to recognize serious defects affecting both ownership and title, and he instructed the county recorder to begin correcting inaccurate planning references while the remaining legal issues continued through the proper process. As the hearing ended, Benjamin quietly handed me another certified document prepared that morning. It was the official notice required to begin foreclosure proceedings under the unreleased mortgage if I chose to exercise the legal rights that had passed to me through succession. I stared at the paper for several seconds because I understood what it represented. Filing that single document would place every one of the 13 lakefront retreats into a legal process that could completely change who controlled the entire property. And the deadline for making that decision expired before the courthouse closed that very afternoon. I have learned that the most powerful legal document is often the one nobody believes you will actually file. I looked at the foreclosure notice for several long moments before signing my name. Benjamin Foster reviewed every page one final time, making certain every legal requirement had been satisfied before we walked together into the county recorder's office. Olivia Bennett carefully accepted the certified documents, verified the supporting records, and officially recorded the foreclosure notice against the unreleased mortgage that remained attached to the entire parcel. The process was remarkably quiet. There were no dramatic speeches, no arguments, and no celebration. A few signatures, several official stamps, and decades of assumptions began changing direction. Once the filing was complete, Benjamin explained that every party with a recorded interest would receive formal notice under the procedures required by law. That included the Homeowners Association, the developer's legal successor, and every organization connected to the property. By the time we left the courthouse, the legal process had officially begun. News traveled much faster than I expected. Before I reached the lakeside retreat, Melissa Grant was already waiting outside the rental office with several members of the Homeowners Association board. Unlike our first meeting, nobody insisted the shoreline belonged to the association. Instead, Melissa calmly asked Benjamin to explain exactly what foreclosure meant for the 13 retreats. He answered honestly. The filing itself did not immediately transfer ownership or remove anyone from the property. It simply began the legal process created to resolve the unreleased mortgage and every interest attached to the parcel. If the defects remained unresolved within the required period, the foreclosure sale would proceed according to state law. Melissa quietly nodded because she understood the difference. The board members asked whether the association could simply produce additional documents proving ownership. Benjamin encouraged them to search every archive available because if valid recorded evidence existed, everyone wanted to see it. That afternoon, the Homeowners Association opened decades of storage boxes containing old meeting minutes, legal correspondence, financial ledgers, and development files collected by previous boards. I joined Benjamin and Olivia at the county administration building while the association completed its search because we wanted every relevant document reviewed by the same objective standard. Several hours later, Melissa arrived carrying 2 large binders she believed contained the final evidence supporting the association's position. The hearing officer agreed to examine everything immediately. One document after another confirmed only internal board decisions, maintenance budgets, rental policies, insurance records, landscaping contracts, and community newsletters. None transferred ownership. Finally, Melissa presented the document every previous board had trusted more than any other. It was a memorandum prepared during the original development describing the future intention to dedicate the shoreline for community use after legal requirements had been completed. Benjamin carefully compared it with the certified deed before handing it to the county attorney. After reviewing the memorandum, the attorney explained that it expressed future intent but created no present ownership because it had never been recorded and had never been executed with the legal documents required to transfer real property. The room became completely silent. The one document everyone believed would save the Homeowners Association actually confirmed that the transfer had been planned but never completed. Melissa slowly closed the binder without saying a word. She finally understood that every board before hers had mistaken a proposed plan for a completed legal act. As the meeting concluded, the hearing officer announced that no newly presented evidence changed the foreclosure process already underway. The statutory waiting period would continue, and unless a court ordered otherwise or valid recorded ownership documents appeared before the deadline expired, the foreclosure sale would proceed on the scheduled date only 6 days away. I have learned that deadlines expose the truth more effectively than arguments ever can. During the 6 days following the foreclosure filing, every opportunity existed for someone to produce a recorded document proving the Homeowners Association legally owned the shoreline or the 13 lakefront retreats. Benjamin Foster checked the county records every morning. Olivia Bennett monitored every newly recorded filing. Andrew Collins reviewed every historical reference that anyone submitted. Nothing changed. No deed appeared. No easement surfaced. No forgotten transfer emerged from an old archive. The official record remained exactly as it had been when I first walked into the county records office with my grandfather's deed. On the morning of the foreclosure sale, the courthouse was unusually busy. Representatives from the Homeowners Association arrived early, along with attorneys for the original developer's successor, county officials, title professionals, and several observers who had followed the case from the beginning. Melissa Grant greeted me politely before taking her seat. She looked tired but composed. She quietly admitted that she had spent nearly every evening searching through decades of association records, hoping to find something that would legally resolve the dispute. Instead, every search had confirmed the same painful conclusion. The association had managed property it genuinely believed belonged to the community without ever possessing recorded ownership. When the foreclosure proceedings officially began, the county attorney summarized the complete record. The uninterrupted chain of title remained with my family until my inheritance. The mortgage had never been released. The 13 retreats occupied a single undivided parcel. The planning maps never transferred ownership. The historical correspondence proved the original developer knew the ownership issue remained unresolved before construction started. Every critical fact supported the same legal conclusion. The hearing officer asked one final time whether any party wished to present additional recorded evidence affecting ownership, or the mortgage. The room remained silent. After allowing the required waiting period, the hearing officer announced that the foreclosure would proceed according to state law because every statutory requirement had been satisfied. The legal interest secured by the unreleased mortgage merged with my existing ownership rights through the foreclosure process, eliminating every competing claim that depended upon the defective title. There was no dramatic celebration. No one applauded. Everyone simply understood that decades of administrative assumptions had finally reached their legal conclusion. Melissa approached me after the hearing ended and apologized once more for insisting the shoreline belonged to the association when we first met. I told her I never believed she had acted with dishonest intentions. She had trusted records that should have been verified years before she became president. We shook hands because the dispute had always been about documents rather than personalities. Outside the courthouse, the investment company confirmed it was permanently withdrawing from the purchase, explaining that it would not pursue property burdened by such extensive historical defects. As we left, Benjamin handed me the final certified foreclosure documents showing that the legal process had been completed exactly as required. For the first time since returning to the lake, every official record pointed in the same direction. The 13 retreats, the shoreline, the docks, the marina improvements, and every permanent structure standing on that parcel now fell under my lawful control. I looked across the lake later that afternoon as families continued enjoying the peaceful water, completely unaware that the ownership beneath their feet had legally changed that very morning. Standing there, I realized the hardest decision was no longer how to recover my property. The hardest decision was determining what kind of future that property should have now that it had finally come home. I have learned that winning a legal battle does not truly matter unless you also decide what kind of person you become after the paperwork is finished. A week after the foreclosure was finalized, the county completed every remaining recording required to update the public records. Olivia Bennett confirmed that the corrected chain of title had been entered into the official system. Andrew Collins issued a final title opinion stating that the historical defects had been resolved through the foreclosure process. And Benjamin Foster handed me the last certified document with a smile that reflected relief more than celebration. After months of uncertainty, every official record finally agreed with every legal boundary on the ground. I spent the next several days walking the shoreline my grandfather had loved for most of his life. The lake looked exactly as it had when I first arrived, but everything felt different because uncertainty had been replaced by clarity. I watched families fishing from the docks, children skipping stones across the water, and visitors enjoying peaceful evenings without realizing how close the property had come to becoming trapped in decades of unresolved legal confusion. That convinced me the retreat deserved a future built upon transparency rather than another round of conflict. My first decision was to keep the retreat operating without interruption so employees could continue working and existing reservations would be honored. Benjamin helped prepare new operating agreements that clearly reflected the corrected ownership records, and every guest received exactly what had been promised before the legal dispute was resolved. I also invited Melissa Grant to meet with me one final time. She arrived carrying a notebook filled with ideas for helping residents adjust to the changes. She apologized once again for everything that had happened, but I reminded her that she had chosen honesty when the evidence became impossible to ignore. That decision mattered. Instead of treating the Homeowners Association as an enemy, I offered a long-term recreational access agreement allowing neighborhood residents to continue enjoying walking paths, fishing areas, and community gatherings along portions of the shoreline under clearly written legal terms recorded with the county. For the first time, everyone knew exactly what rights existed because every agreement would now be properly documented instead of assumed. Melissa accepted the proposal with visible relief, and together we attended a community meeting where Benjamin explained the corrected property records in plain language so every resident understood how the confusion had developed and why proper documentation protected everyone involved. No one celebrated another person's loss because there was no need. The greatest victory was replacing uncertainty with facts. Several months later, the lakeside retreat had earned a reputation not because of the foreclosure but because every reservation, every property boundary, every lease, and every operating agreement had become an example of careful legal transparency. Visitors came for the lake, the fishing, and the quiet evenings, never realizing they were enjoying a place whose future had been secured by old deeds, forgotten records, patient investigation, and respect for the law. Sometimes I stand on the dock early in the morning and remember the day I first discovered 13 luxury retreats built on land that had never stopped belonging to my family. People often imagine that justice arrives with loud victories and dramatic endings. My experience taught me something much simpler. Justice arrived through county records, certified surveys, historical files, honest professionals, and the willingness to follow the law from beginning to end. In the end, nobody lost because someone else was stronger. The truth simply remained where it had always been, waiting patiently inside the official record until someone finally took the time to read every page.